So the Fifth Circuit just partially granted the ATF's request for an emergency vacatur in the Vanderstock frames and receivers case. So let's talk about what's going on. But real quick before you jump in this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated rows for organizations like FBC, who filed this lawsuit, Vanderstock, and so some of those proceeds go to these organizations so they can file lawsuits. If you're interested, you can check out Blackout Coffee using the links down below, and also if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing the Fifth Circuit decision that was just released in the Vanderstock v. Garland case. The Fifth Circuit has partially granted the ATF's request for an emergency vacatur in this frames and receivers case. Now, if you're not aware, recently Judge O'Connor in Texas granted a limited preliminary injunction in favor of two companies, which was Defense Distributed and then also 80% Arms. This limited injunction protects their company and their customers from having the ATF's frames and receivers rule enforced against them. In response, the ATF requested that the Fifth Circuit strike down that injunction because they claimed Judge O'Connor was defying the Supreme Court in their recent 5-4 emergency stay that was issued in this case. The Fifth Circuit, in response, partially agreed with the ATF that the preliminary injunction should be vacated, particularly to part of the injunction that protected the customers of the companies, but he denied it as to the companies themselves. And the Fifth Circuit did this because they are taking the ATF's word that the agency will not enforce the rule against these specific customers. Now, in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule while this case was making its way through the process. On review, Judge O'Connor granted a limited preliminary injunction against the ATF, which prevented the ATF from enforcing the rule against that one company, which was Tactical Machining, and then also their customers. After that, other companies like Blackhawk Manufacturing Group, Defense Distributed, and then also 80% Arms sought to intervene in the case as new named plaintiffs. They also asked the court there, Judge O'Connor, to grant the same limited protections, which was granted to that one company, Tactical Machining. And ultimately, the court did extend those protections to those new companies and also their customers. After that original preliminary injunction stage, FBC and the plaintiffs sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant that motion for summary judgment and vacated the frames and receivers rule in its entirety, and that was a nationwide vacatur. Well, of course, the ATF was not going to let that summary judgment sit, so they filed an appeal up to the Fifth Circuit. Then the ATF sought for an emergency stay of that decision, and the Fifth Circuit denied it. So then they went crying up to the Supreme Court. They filed the emergency application to the Supreme Court, which was submitted to Justice Alito, and then he referred it to the full court. And in a 5-4 decision, the Supreme Court agreed with the ATF and stayed the enforcement of the summary judgment and that nationwide vacatur while the Fifth Circuit is reviewing the appeal of the summary judgment. Well, after the Supreme Court issued that 5-4 emergency stay, 80% Arms went back to Judge O'Connor and sought an emergency motion for a preliminary injunction. They asked the Judge O'Connor to put back in place the prior preliminary injunction, that limited injunction that protected their company and then also their customers. And on review, Judge O'Connor agreed and granted the limited preliminary injunction and put in place back those protections for the company and their customers. Of course, the ATF could not live with another loss, so once again they filed an appeal up to the Fifth Circuit, and they argued that Judge O'Connor is directly defying what the Supreme Court just said in their 5-4 order. The ATF argued that Judge O'Connor could not issue the injunction because the Supreme Court already prevented any relief in this case. Now, last week, the Fifth Circuit heard arguments on the emergency motion, and today we got an order from the Fifth Circuit. The Fifth Circuit has granted the vacatur in part and also denied it in part. Now, the order of the court reads that we agree with the government that the district court's injunction sweeps too broadly. Injunctions that afford relief to non-parties are potentially problematic, and it appears that the district court's injunction sweeps too broadly insofar as it affords relief to non-party customers. That is particularly true because the government has been adamant in both writing and at the oral argument on this motion that it will not enforce the final rule against customers who purchase regulated frames or receivers and who otherwise lawfully are entitled to purchase firearms. Of course, if circumstances change, the district court is free to narrowly tailor injunctive relief to meet the changed circumstances. But as things stand today, the government is correct that the injunction cannot extend to non-party customers. Now, what it appears to me that the Fifth Circuit is doing here is saying that the protection for all potential customers is too broad. Therefore, they are vacating that part of the injunction that was granted by Judge O'Connor. A big part of this Fifth Circuit doing this, and one of the rationales that they are saying why they are doing this, is the fact that the ATF represented to the court on multiple occasions in both writing and at the oral arguments is the fact that the ATF says they will not enforce the rule against customers of these companies. Instead, it seems like the ATF is claiming that they only want to enforce this rule against potentially prohibited people who maybe want to purchase these items. Now, to me, this is a big issue, and I kind of take the ATF's words and promises with a grain of salt. I do not trust what the ATF is saying, and I think the ATF, flip-flops quite often. We know they flip-flop quite often on what they say they're going to enforce and then not enforce. Now, it's concerning to me that the court here is just taking the ATF's word, but the court here did say if circumstances change, maybe if the ATF does decide to very strictly enforce it against all customers, then maybe the plaintiffs here could go back to Judge O'Connor and seek additional relief. However, the Fifth Circuit denied the vacatur as to the part that protects the company like Defense Distributed and then also 80% Arms. The Fifth Circuit did not agree with the ATF's argument that the district court was defying what the Supreme Court said in their recent 5-4 order. The Fifth Circuit agreed with what we've been saying here on the channel this whole time, which is that a relief like a nationwide vacatur or a vacatur is very different from what was granted in the injunction. Those are two different types of remedies. And on this specific issue, the Fifth Circuit stated in the order that we are unpersuaded by the government's insistence that the district court flouted the Supreme Court's August 8th order. There is a meaningful distinction between vacatur, which is a universal remedy, and an injunction that applies only to named plaintiffs, which is a traditional equitable remedy. They go on to state then that at the end of the day, we think four things are paramount. First, inferior federal courts must exhibit unflinching obedience to the Supreme Court's orders. Second, the court has directed us to be skeptical, if not altogether unwilling, to order universal relief that extend to non-parties. Third, insofar as possible, we should have orderly judicial review in which the status quo is maintained and the legal rules sorted without asking courts to make monumental decisions in short-fuse emergency dockets. Fourth, and finally, courts should be able to review the ATF's 98-page rule and the decades of precedent it attempts to change without the government putting people in jail or shutting down businesses. For these reasons, the government's motion is granted in part, the district court's preliminary injunction is vacated as to non-parties, and the government's motion is otherwise denied. So what are the main takeaways about what the Fifth Circuit just did in this order? Well, the ATF had the request for the injunction to be vacated in part granted by the Fifth Circuit, so they got a partial granting of their motion. However, the ATF still did not technically win in my eyes. The customer's part of the injunction was vacated, but only because the ATF submitted to the court that they will not enforce the rule against any type of typical law-abiding customers, potentially that they only want to enforce it against people who are prohibited under federal law. Therefore, the Fifth Circuit seemed to find that the customer's injunction was overbroad, and the Fifth Circuit appeared to want to avoid any appearance of any nationwide injunctive relief that could potentially run contrary to what the Supreme Court just said in their 5-4 order. But the ATF's vacatur request was also denied in part, so the ATF will not be able to enforce the rule against these companies like Defense Distributed and then also 80% Arms. And based on that, I would say although the ATF technically got a win on part of the request, it really overall was just actually a loss. That's because the overarching result of this order is the fact that the ATF cannot enforce the rule against companies, and then also they are saying that they're not going to enforce it against customers. So the Fifth Circuit is saying, okay, we're going to take you for your word. Don't enforce it against customers, and we'll grant you partial relief that you're requesting, but ultimately you're still not going to be able to enforce against customers. Now, we will have to wait and see how the ATF responds to this. Their track record in any of these cases, in this case and other cases, is that whenever they get it lost, they decide to appeal it up to the next level. But if we get any more information, of course, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Also want to mention that a lot of you guys have been mentioning that you've been unsubscribed to the channel, so just double check that you're still subscribed to the channel. And then also, if you're not currently subscribed to the channel, please consider subscribing to the channel. I think it's about 60% of all viewers here on the channel are actually not subscribed to the channel. So if you've been watching for a long time, you find value in this video and what I do here trying to bring two-way news, please consider subscribing to the channel. That also signals to the algorithm that people appreciate this and they push it out to more people. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.